discussing a recent Massachusetts appeals court decision that came down on September 30th, 2024. It's an important legal update, especially for those involved in the estate planning community or anyone who has a question about terrorem clauses, which are also known as no contest provisions. Now, what does terrorem mean? It's Latin for in fear, and these clauses are designed to put your heirs in fear of losing their inheritance if they challenge your will. This is why they're often called no contest clauses. They serve as a deterrent against beneficiaries who might be tempted to contest the will, knowing that doing so would cause them to forfeit their inheritance. This case, the estate of William F. McLoughlin, is a perfect example of how a no contest provision works and when they are or aren't triggered. So let's go over the facts of the case. William F. McLoughlin Sr. passed away in 2020, leaving behind 6 children. He disinherited one of his sons, William Jr., while leaving the property to his other 5 children, including his son Sean and Thomas. The will also included a no contest provision, which stated that any beneficiary who contested the will would forfeit their inheritance. The goal was to prevent any legal challenges from the heirs. After the will was submitted for probate, William Jr., who had been disinherited, filed a motion to contest the will, asking the court to allow him to file a late objection. He claimed he hadn't been aware of the 2020 will and argued that it was invalid because his father lacked the mental capacity to execute the will. In support of his challenge, Sean, one of the other beneficiaries, provided an affidavit contradicting statements made by their other brother, Thomas. Sean's affidavit raised concerns about the decedent's mental capacity and claimed that their father had Alzheimer's and dementia. And at the time the 2020 will was executed, his father didn't have capacity. Sean's affidavit also alleged that some of the siblings had manipulated their father into making changes to the will. This led to the key question of, did Sean's act of providing an affidavit supporting William Jr.'s objection trigger the no contest provision, causing Sean to forfeit his inheritance? The main issue in the case was whether Sean's affidavit violated the no contest provision in his father's will. The provision had 2 triggers. A beneficiary would forfeit their inheritance if they contested the validity of the will. The provision would also be triggered if a beneficiary joined in any proceeding to contest the will. The personal representative of the estate, Thomas, asked the court to rule on whether Sean's affidavit triggered the no contest provision. Sean argued that he hadn't contested the will or joined in any legal action. He had simply provided an affidavit as a witness. So what's the court's holding? The appeals court ultimately ruled in favor of Sean, reversing the probate court decision. The court held that Sean's affidavit did not trigger the no contest provision. Sean did not personally contest the will, nor did he join the legal action initiated by William Jr. The court emphasized that the no contest provision must be interpreted narrowly under Massachusetts law. These provisions are enforceable, but courts will only disinherit a beneficiary if the beneficiary's actions clearly violate the terms of the clause. In this case, Sean was not a party to the contest, and he merely provided an affidavit, and it did not amount to contesting the will or joining a legal proceeding contesting the will. The reasoning behind the court's decision was grounded in Massachusetts' long-standing practice of narrowly interpreting contest provisions. Courts are cautious about enforcing these provisions because they can lead to harsh outcomes, like disinheriting a beneficiary. Here, the court found that Sean's role as a witness, even though he voluntarily provided the affidavit, he wasn't subpoenaed, was not enough to trigger the contest provision. If Sean had been subpoenaed to testify in court, he would not have been penalized. The court didn't want to penalize someone for simply telling the truth or providing testimony, even if it wasn't favorable to the will. The court also noted that public policy favors allowing witnesses to testify in a will contest. The legal system depends on the ability of courts to gather evidence and hear from witnesses, and courts shouldn't discourage this by enforcing a no contest provision too broadly. So what does this mean for you? For people involved in estate planning, or if you're a beneficiary under a will, it highlights the importance of understanding the specific terms of any no contest provision in a will. While these provisions are designed to prevent will contests, they're not automatically triggered by every action that a beneficiary takes. If you're an executor, trustee or a beneficiary are dealing with a potential will contest or a no contest provision, it's critical to seek legal advice before taking any action. This case shows how nuanced the enforcement of these provisions can be. If you have questions about a no contest provision, whether you're planning your own estate or you're involved in a dispute over a will, I encourage you to reach out to my office. These clauses can be complicated, and it's important to understand how they may affect your inheritance or the wishes you want to protect in your own estate plan. Feel free to contact us today to discuss your situation. We're here to help, and we'll help you navigate the complexities of estate planning and make sure your rights are protected.